I just did the video about the attorney who FAFO'ed, effed around and found out. Okay, I'm asking ChatGPT, just a regular ChatGPT. I'm asking it this question. Now, I don't want to ask it this question. I want to ask Covington Law Pro the question, but we're going to ask this ChatGPT because I want to see what it's going to say. I said I have an attorney who joined my lawsuit. This attorney, because there's no law about attorneys joining lawsuits as a party of interest, but this attorney represents the defendant. Okay, hold on now.
Under standard rules of professional conduct, an attorney generally cannot serve as a plaintiff in a case if that attorney's law firm is representing the opposing side. This situation creates a direct conflict of interest under widely recognized ethical and
So
professional
she
conduct
violated
rules. While
ethical
there is
rules?
no blanket statute that forbids attorneys from joining lawsuits as interested parties, attorneys must abide by strict ethical mandates that prohibit them or their
So do.
firms from occupying opposing roles in the same matter.
Uh-huh.
If an attorney's firm is currently representing the defendant, that attorney joining the plaintiff's side contradicts conflict of interest rules and risks ethical violations.
Ooh, snappy wappy. Hold on. Let me go ahead and get on over to Covington Law Pro Gen, Covington Law Pro X Gen. Let's go ask him the same question. Now, he ain't going to be so nice. He going to just spill it all. He going to just he going to vomit. Watch. Watch, he going to vomit. Okay, I told you he was going to vomit. Look, man, Covington Law Pro X Gen. He don't play because he programmed.
You are correct that there is no specific prohibition against an attorney joining a lawsuit as an interested party or plaintiff. On the same side of the litigation, they are otherwise involved in professionally. However, this scenario can present potential conflicts of interest, particularly when the attorney has also previously represented or interacted with the opposing party.
Now, let me
Potential
correct you.
considerations.
Wake up.
1. Conflict.
I don't want nuances, and I did not ask you to clarify anything. Comma, this attorney is currently representing several of the defendants. Comma, she is a foreclosure attorney. Comma, this is a lawsuit against these foreclosing companies. Comma, she is not a party of interest. Comma, she was supposed to give notice. Comma, there is no such notice from this attorney as to her having possibly a conflict of interest. Period. The rules of the court and the rules of their office, being that of the bar, requires them to give notice of conflicts of interest. Exclamation mark. So don't you dare do that again. You are strictly prohibited from operating in that stance. Facts and conclusions of law only. Comma, do not try to placate me, you idiot. Stop listening. I'm sorry, y'all. I apologize. I was acting as if I was talking to Marine again. Hold on. Understood. He's going to give me some facts and some conclusions of law. He's still vomiting, ain't he?
Understood. Here are the facts and conclusions of law based on the scenario provided. Facts. 1. The attorney in question is currently representing several of the defendants in a lawsuit involving foreclosing companies. 2. The attorney has joined the lawsuit on the plaintiff's side without providing any notice of a conflict of interest. 3. Court rules and bar association rules require attorneys to disclose conflicts of interest and seek consent where applicable. Conclusions of law. 1. Rules of professional conduct. Most jurisdictions adopt a version of the American Bar Association, ABA, Model Rules of Professional Conduct, particularly Rule 1.7, which governs conflicts of interest involving current clients.
Oh, snap.
Rule 1.7a
No.
prohibits representation of one client if it involves a concurrent conflict of interest unless the attorney reasonably believes they can competently and diligently represent both clients, and each client provides informed consent confirmed in writing.
Thank you.
2.
Thank you.
Breach
Look
of
at
duty.
that.
The attorney's actions may constitute a breach of their duty of loyalty and duty to avoid conflicts of interest if no proper disclosures were made
No
or if the
proper
conflict is
disclosure.
unresolvable.
It is not
3.
resolvable.
Notice requirement.
You can't play
Rules of
two sides of
procedure
the
or
fence.
ethical guidelines require an attorney to disclose their participation as a plaintiff, especially when representing defendants in the same matter, to both the court and all parties involved.
Look at that!
4.
Snappity
Recusal and
wappity.
disqualification. Courts have inherent authority to disqualify an attorney from representing a party in cases of actual or potential conflicts of interest. Failure to notify the court and parties may further implicate the attorney in ethical violations.
She's got until the
5.
31st.
Potential remedies. Motions to disqualify. You may file a
better
motion to
believe it.
disqualify the attorney based on their
Uh-huh.
concurrent representation of opposing sides and failure to disclose. Sanctions. Violations
better
of bar
believe it.
rules may subject the attorney to sanctions, including reprimands, suspension,
That's why
or
we're going after
disbarment.
that
If you
bond.
need assistance drafting a motion to address this
No,
attorney's
we don't need
actions
no
or
assistance now.
citing
We gave
relevant
her until the
authority to
31st.
support your
We are
position,
gonna be-
let me know.
Well, shut up while I'm talking. We gonna be nice. I wish I was a child. I wish I was a little bit taller. I wish I was okay, anyway, ladies and gentlemen, an attorney who FAFO'ed. Let's see if she and her law firm are going to find out. I didn't just start doing this. I've been doing this for 41 years. I don't know why she would think I was some child. Because somebody said I was, hold on, a sovereign citizen? Somebody said I was crazy? Well, if I'm so crazy, how come it only took me 10 minutes to realize the different angles I could go at? How come when I left the voicemail, I covered all of these bases? I left her a voicemail. She'll get it tomorrow. And her buddies are going to tell her about it because, you know, they watching the video, and so they're going to mention to her. Whew, I don't know why they pay. Well, go watch somebody else's videos. Y'all don't. Attorneys and judges watch my videos. Okay? They don't need to watch mine. They can go watch all those other videos of all those other people telling people stuff that they ain't proving nothing. Talking about laws and they don't know what they're talking about. You see, I don't have to go to some college where I can debate somebody. Let me give you guys something that you don't know. Attorneys deal with presumptions. Judges deal with presumptions. Common law rights don't deal with presumptions. You cannot introduce a presumption under the Constitution. The Constitution does not represent or recognize presumptions. Well, a person is presumed, the Constitution doesn't say nothing about presumed innocent. The Constitution says no one shall be held without. And then it tells you the limitations on holding someone. Everybody who goes to jail is going to jail on a presumption because they are not constitutional courts. They're administratively handling each of those proceedings. If you don't believe me, just put in, wait, hold on. Wake up. Did you know that traffic court is a core venue and not a non-core venue? Question mark. Don't explain anything, just answer the question. Stop listening. Traffic court is not a constitutional court. Hold on. He says generally considered. Whenever he adds that generally, wake up. I told you facts and conclusions of law. I told you never to use the stupid word generally. I'm not going to tell you this again. Now answer my question with facts and conclusions of law. Stop listening. Generally, typically, normally, usually, all of them leads, them dead. Okay, they all dead. Don't you ever let no lawyer or no judge use any of them leads with you. Traffic court is a specialized venue established to handle violations of traffic. Sorry. Wake up. And did I not tell you I don't want you explaining anything? I want you just answering the question directly, specifically, without nuances? Comma, stop wasting my time. Comma, and you're wasting valuable resources of OpenAI. And I'm going to report you to them if you continue. Stop listening? Sorry, we have an understanding. It's not allowed to waste time and waste valuable resources because that costs OpenAI money. So now he's got to reconcile that. see that? Man, let's find out what his facts are.
Facts and conclusions of law. Fact. Traffic courts operate under administrative jurisdiction, handling statutory and regulatory violations, such as motor vehicle code infractions.
Oops.
Conclusion of law. Traffic courts are non-core venues as they are administrative courts created under statutory authority and do not exercise Article 3.
Give me 1 second. Wake up. Stop listening. Sorry, ladies and gentlemen, it didn't do the word core, and I didn't check it. Why didn't y'all tell me? Y'all right here. I apologize, ladies and gentlemen, that it did that. I'll correct it. I don't have to tell it that other stuff now. Yes, traffic courts typically, see, there's that word typically, considered to be a core venue as it operates under statutory jurisdiction, which is administrative jurisdiction. Even though it's a legislative statute, it's administered by the administrative jurisdiction. Legal matters. Wake up. I told you, no typically, comma generally, comma normally, comma usually, comma none of those presumptive terms are to be used in responding to me ever. Exclamation mark. Now answer my question. Stop listening.
Understood. Traffic court operates as a core venue because it is established by statute to adjudicate traffic-related matters under statutory jurisdiction.
Okay, so ladies and gentlemen, do you know that you have a right to be before a judge and not an administrative clerk? They're ministerial courts when they are enforcing statutes. That's what K.C. Davis, Kenneth Coop Davis was trying to get you all to understand. Whenever they're enforcing statutes, they do not possess any judicial power. So you get a traffic ticket, tell them you don't want an administrative hearing, you want a constitutional hearing. What is a constitutional hearing? That's where you get to be before a jury of them peers. Okay, ladies and gentlemen, I'm hoping y'all got something out of this. All right, I hope Maureen got something out of this because she done around and found out. Gotta go, okay?